Another showdown is unfolding between the executive branch and the federal district courts. The battle lines have been drawn and the nation is hanging in the balance waiting for the final decision. In Office of Personnel Management, OPM, v. American Federation of Government Employees, AFGE, the United States government sought an emergency stay from the Supreme Court to halt a district court's preliminary injunction that required reinstatement of thousands of probationary federal employees. The Ninth Circuit denied the government's motion to stay the injunction, but Circuit Judge Bade dissented and offered a detailed legal defense of the executive branch's position. Government's arguments for emergency relief, as summarized in the brief and Judge Bade's dissent. 1. Standing and jurisdiction, Article 3 and threshold issue. The government argues that the organizational plaintiffs' unions lack Article 3 standing, which would deprive the court of jurisdiction. Law professor Samuel Bay opines, the universal injunction is inconsistent with basic principles about the precedential authority of a district court. It is inconsistent with rules about the issue preclusive effect of a decision against the government. And the universal injunction has an asymmetric effect. 100 people can challenge a federal policy, and if the government wins 99 of the cases, it won't matter, as long as one plaintiff wins and gets a universal injunction. Under FDA v. Alliance for Hippocratic Medicine, 2024, and Lujan v. Defenders of Wildlife, 1992, plaintiffs must prove a concrete injury that is traceable to the defendant's action and likely to be redressed by the requested relief. The government contends the alleged injuries of the organizational plaintiffs are not redressable because reinstating terminated employees might not result in those employees returning to the same duties or providing the services the plaintiffs seek, and the agencies retain discretion to lawfully reassign or terminate them again. OPM key case support arguments. Simon v. Eastern Kentucky Welfare Rights Organization, a United States Supreme Court case decided in 1976. The court held that relief must result in likely, not speculative, benefits. Sprint Communications v. APCC Services, 2008. Redressability cannot be speculative. The Supreme ruled in order to have Article 3 standing, a plaintiff must adequately establish 1. An injury in fact, a concrete and particularized invasion of a legally protected interest. 2. Causation, a fairly traceable connection between the alleged injury in fact and the alleged conduct of the defendant. And 3. Redressability, likely, and not merely speculative, that the plaintiff's injury will be remedied by the relief plaintiff seeks in bringing suit. 2. Executive authority and limits on judicial power. Article 2, implied argument. The government suggests the judiciary lacks authority to direct agency personnel decisions, citing Article 2 implications. Article 2 vests the president with the power to manage executive branch personnel through agencies like OPM. A federal court mandating specific personnel actions, like employee reinstatement, encroaches on executive discretion in employment matters. Key case support. Vitarelli v. Seaton, 1959. This case reinforces that reinstatement orders are subject to the agency's lawful authority. MS v. Brown, 2019. Courts cannot redress injuries if they lack the power to grant the requested relief. 3. NCAN Stay Factors Analysis, based on NCAN v. Holder, 2009. Factor 1. Likelihood of success on the merits. The government argues it's likely to prevail because the plaintiffs lack standing. The district court lacked jurisdiction. The injunction improperly interferes with executive personnel authority. Factor 2. Irreparable harm. Forcing OPM and the agencies to reinstate thousands of employees causes irreparable harm because it imposes immediate administrative burdens. It forces the executive to act under a court order in a matter potentially outside judicial authority. Supporting Case Ute Indian Tribe v. Lawrence, 2022. A sovereign party suffers irreparable harm when required to litigate a claim in a court without jurisdiction. Factors 3 and 4. Harm to others and public interest. Judge Bade dissent argues that since the two most critical NCAN factors are satisfied, the court need not weigh the others. In Enken, the OPM legal brief highlights the first two factors are the most critical, and we apply a sliding scale approach that balances these four factors so that a stronger showing of one factor may offset a weaker showing of another. Majority found that the plaintiffs likely had standing, their injuries were concrete, and the district court did not clearly err, citing the Fellowship of Christian Athletes v. San Jose Unified School District, 9th Circuit 2023. Organizations may sue on behalf of members if they meet three-part standing test. Judge Bade dissented and strongly disagreed, arguing, the injuries were speculative, relief was not redressable, and jurisdiction was lacking, meaning the case should not proceed. Conclusion: potentially most favorable to the government. The government, invoking Article 3 jurisdictional limits and executive discretion under Article 2, argues the district court's preliminary injunction is improper. It asserts that organizational plaintiffs lack standing because the remedy they seek, reinstatement of employees, won't necessarily result in the outcomes they claim. Reinstating the terminated employees does not mean that they will return to the same positions and assignments, or that the agencies will provide the services that the organizational plaintiffs desire. The executive further contends the judiciary lacks power to direct internal personnel decisions. These arguments, supported by precedent and articulated in Judge Bade's dissent, present the strongest constitutional and procedural case for granting an emergency stay. In summary, the Supreme Court's decision in OPM v. AFGE will likely act as a linchpin for the 2 to 10 active lawsuits challenging the President's firing of probationary employees as of April 7, 2025, affirming the President's executive authority on employment matters. For probationary employees, the consequences of an agency failing to follow reduction in force procedures depend on whether the violation involves statutory rights or collective bargaining agreement (CBA) protections. Let's break this down. MSPB appeal rights. Probationary employees generally do not have the right to challenge a RIF through the Merit Systems Protection Board (MSPB) unless they meet specific criteria under 5 U.S.C. Section 7511. This includes completing 1 year of continuous service in the competitive service or qualifying as a preference-eligible veteran. Additionally, they can appeal if they claim the RIF decision was based on partisan political reasons, marital status, or other prohibited personnel practices, such as whistleblower retaliation, union grievances, and arbitration. If the CBA covers probationary employees, the union may be able to grieve RIF-related violations under the contract. However, some CBAs exclude probationary employees from full grievance rights, so their options may be limited. EEOC complaints. If a probationary employee believes they were selected for a RIF based on discrimination, such as race, gender, or disability, they can file a complaint with the Equal Employment Opportunity Commission, EEOC. OSC complaints for whistleblower retaliation. If a probationary employee was targeted in a RIF for engaging in protected activity, such as reporting waste, fraud, or abuse, they can file a complaint with the Office of Special Counsel, OSC. Agency-level corrective actions. Even probationary employees can seek relief if an agency fails to properly conduct a RIF, such as not following tenure group rankings or competitive area requirements. If an agency is found to have violated RIF rules, corrective actions, such as rescinding terminations, may be ordered. Understanding these rights and remedies is essential for probationary employees navigating the complexities of RIF procedures. Until next time, as we dive into more legal battles, don't forget to subscribe so you don't miss another episode as we report on the ongoing court cases. Hit that notification bell and follow me on X at AndreaFreedom76. Follow my YouTube channel at AndreaSchaffer 5645. Thanks for watching and God bless America.